I too would like to begin by acknowledging the traditional custodians of the land on which we meet and paying my respects to their elders past and present. I feel a little apprehensive speaking tonight. One of the earlier speakers said that the task was to speak in few words. I've been given 15 minutes and my task is in that time, I think, not to be too subversive. But I think I can begin with the proposition, which I hope will not be characterised as too subversive, that legislation is a blunt tool for addressing future risk or dangerousness. While I was looking for the High Risk Offenders Act to reread the current version, because I always forget that it's an act that begins with the word crimes, I was searching through acts beginning with the letter H for high risk offenders, and I came across a fun fact, which is that contained in the Hairdressers Act 2003, which seems to be an act like the High Risk Offenders Act, also passed hastily in response to an isolated incident that sparked panic through probably both Houses of Parliament, if not through the whole community. The long title of the Act is that it is an act to prohibit unqualified individuals from acting as hairdressers. I imagined this legislation was passed in response to an incident perhaps involving Ray Hadley and his attending a hairdresser, an elegant young man who may have run his fingers through Hadley's hair and suggested he might go for a man bun. Hadley turning to the young man and saying, "Are you even qualified as a hairdresser, citizen?" The Attorney-General hastily responding on talkback television and immediately promising to pass legislation to address the public vice of unqualified hairdressers. The Act seems to have two main provisions. One is that, this is my favourite part, did you know it's actually an offence for a person to to act as a hairdresser for reward, fee or gain unless qualified as a hairdresser. And the Act also provides for some what you might term compulsory powers, which is that a demand for documentation. So you can, as a citizen, or presuming that you work for the appropriate minister, go into any hairdresser and say, "Do you have a Cert 4?" And if they don't produce the document, that's also an offence. But this article by Harry Hobbs and Andrew Trotter treats obviously with a more serious subject, and it is one, as I say, in respect of which I do need to be careful not to be too subversive. But they describe this question of the battleground between liberty and security as a familiar battleground for the old foes of security and liberty, with crossfire between the judiciary and the executive. Now, I would cavil with the term crossfire. Certainly, I think there is healthy debate between the judiciary and the executive about those old foes of security and liberty. I prefer, rather than thinking of it as a battle involving crossfire, as something perhaps involving a more, what might in the olden days have been termed gentlemanly exchange of writing to each other. One of the judges of the district court has a lovely story about the way judges should deal with being overturned on appeal. You shouldn't feel badly about it. The Court of Appeal are our pen friends. We write to them and they write back to us. But I can this evening present you with a real example of an exchange between my pen friends on the executive arising out of a particular experience with a case involving the High Risk Offenders Act, which sits closely next to the Hairdressers Act in Osley. And it begins with the proposition that predicting risk is inherently challenging and empirically impossible, and that's a quote from the article by Harry Hobbs and Andrew Trotter. They use the term, and this is again a quote from towards the end of their article, squaring the circle doesn't mean abandoning the protection of the community. And again, I pause again so as to pad the time and not be subversive with another fun fact. I don't know whether they knew that the term squaring the circle comes from a mathematical challenge that challenged mathematicians for many centuries of attempting to calculate the area of a circle by squaring it. And there was actually a bill passed in Indiana, a bill presented to the Parliament in Indiana, which attempted to solve this mathematical problem that had eluded mathematicians for centuries. In case any of you have forgotten, the area of a circle is the square of its radius multiplied by pi, pi being the ratio of the circle's circumference to its diameter. But pi is a mathematical constant, but it's also an irrational number, so it can't be expressed as a fraction, and expressed as a decimal it's something like 3.14159 continuing. Bill 246 presented to the 1987 session of the Indiana General Assembly tried to overcome that problem by declaring that the ratio of the circumference of a circle to its diameter is 4 to 5/4, or otherwise 4 over 1.25. So in other words, the effect of the legislation was to approximate the value of pi to 3.2. And to mathematicians, this is heretical. And I'm not being entirely flippant, because it seems to me that with legislation such as the high risk offenders legislation, Parliament seeks to derive comfort from allocating what people might regard as a constant value to something that is simply not able to be given a constant value. And so I come to my pen pals on the executive, a case which I decided, and it's over, so I feel comfortable at least talking about the facts of this case so far as they're reported. It was a decision of the State of New South Wales and Donovan. It was a case where a continuing detention order was sought, and under the legislation at that time, the finding which triggered the court's authority to make a continuing detention order was based, as it still is, on the existence of an unacceptable risk. But to the extent that politicians or people who read the Act think that that is a term which has the kind of certainty that you can give pi by calling it 3.2, that is elusive in my view. An issue that arose under the legislation before it was amended late last year, which was the legislation under which I determined this case, was whether adequate supervision could be provided for an offender in the community. So at that time, the Act created a hierarchy which was intended to provide that a continuing detention order could only be made if an extended supervision order would not provide adequate supervision in the community. And there was a contest in the hearing at first instance as to the relationship between that first necessary finding as to whether someone posed an unacceptable risk and whether a supervision order would provide adequate supervision. This is where I think the relationship at a practical level between judiciary and executive, and at a theoretical level between what the authors of the article term the old foes of security and liberty, becomes particularly acute, because a judge in an application under this legislation is presented, leaving aside the difficulties which I think a lot of people don't really have any familiarity with, which is the way in which the judges in the Common Law Division are allocated their work. We receive our work on fairly short notice. We often receive truckloads of folders delivered to chambers the night before a hearing. But what the legislation requires is that the people who work in corrective services, who really do have the greatest familiarity with these individuals and the greatest ability to present what is required in terms of supervision or addressing the dangerousness of a particular person, are expected to effectively square the circle and bring that material into a form that a judge can digest, having it provided to them in folders 2 nights before the hearing. And the judge has the extremely difficult task of trying to make this evaluative judgment or assessment of the extent to which an individual poses a risk and the extent to which that can be addressed by adequate supervision under the old legislation. So in the case of Donovan, I had an anxious task, and I concluded that I was satisfied that he posed an unacceptable risk, but I concluded that the proposal put forward for his supervision, which contained a long list of conditions of the kind provided for in the legislation, would provide adequate supervision, and I declined to make a continuing detention order, but I made an extended supervision order. The barrister, when I published that judgment, I pronounced the orders, I refused the application for a continuing detention order, I published my reasons. As my tipstaff was walking the reasons down to the bench, the barrister appearing for the state said, "We want to appeal, Your Honour." And this is all a matter of public record, it's on the transcript, but the intonation which you're going to hear tonight, just confidentially between the 70 or 80 of us, is probably not captured by the transcript. But before the reasons had been seen by the state and when it was announced that there was going to be an appeal, I said in probably a slightly hurt voice, "Don't you want to read the reasons?" And I thought that, arrogant enough to think perhaps when the reasons were read they might have persuaded somebody that I was right. But the decision was appealed, and I'm pleased to say the Court of Appeal did uphold my judgment. What I later learned in the course of preparing for this evening was the angst that caused for, well, I don't know if it was this individual case, although certainly it seems to be an important part of a later parliamentary review of the legislation, because of this vexed question of communication to the court of what is adequate supervision. And the high-risk offenders legislation underwent a review, and then amendments were made which came into force late last year. So I went in the course of preparing for this evening to the report of the review, and being vain and self-absorbed, I searched the word Donovan, which was the decision I've just referred to, and sure enough it featured, I think I would conclude from my reading of the review, it featured as an aspect of the submissions that were put forward, which ultimately formulated into recommendations for amendments to the Act, and the Act was duly amended. The review specifically referred to the difficulty, which I've referred to, of corrective services officers being required to put evidence before the court as to what adequate supervision could be provided for an offender in the community, in circumstances where corrective services were of the view that the person couldn't be adequately supervised in the community. But the court had the task of making that assessment, separated from the task of assessing unacceptable risk, and that was seen to be a vice in the legislation which required amendment. So, excited at the prospect of a clearer Act, I went to the amendments, and I have to say, on my reading of the amendment, I think, again, trying not to be subversive or controversial, I think there are still difficulties, and I think they reflect the fact that that you can't square the circle, and you can't give comfort and certainty in a field with the difficult task of predicting future dangerousness using terms of indeterminate reference or uncertain content. So the whole test of adequate supervision has been removed, and the hierarchy between detention orders and extended supervision orders has been removed, but the Act still requires the court to make a determination as to whether it's satisfied to a high degree of probability that the person poses an unacceptable risk if not kept in detention under the continuing detention order sought by the state. And I don't know how you can form that assessment without considering the circumstances in which the person would be in the community if the continuing detention order wasn't made. I haven't, I confess, had time in the last little while and in the course of preparing for this evening to look closely at how the amendments have been analysed, and I don't know whether other judges of the division have the same concern I do. But it just seems to me that ultimately you come back to an intractable problem when you're trying to address future dangerousness through legislation, which is that it is always going to involve an evaluative judgment based on uncertain material, the best material that the people bringing forward the applications can present in large folders to a busy judge, and ultimately the notion that we can give ourselves a confident way of addressing risk through legislation of this kind is always going to be vexed. I wanted to finish by commending the authors of this article. One of them was sitting in front of me before and now he's moved, but I think that the article presents a beautiful analysis of the ways in which there are reactions to occasions of risk which have variously disproportionate or otherwise consequences. And I noticed one of the things that the article did refer to was the possibility of chemical castration and courts ordering chemical castration. That legislation, I think, first came in, or that authority first came in when I was a prosecutor in the ACT many years ago, when I still had functional knees. That's how long ago that was. And the Chief Magistrate in Canberra had an accused person, or an offender who'd pleaded guilty and was constantly trying to get this boy to come on board to a chemical castration program. And I just remember looking at this boy and thinking, wow, that's a large proposition in the case of a young male to have court-imposed chemical castration. So I welcome this very interesting analysis of those difficult complexities that we face in trying to address the dangerousness of people through legislative responses. Thank you.
Good evening, everyone. I'd also like to begin by acknowledging the traditional owners of the land on which we meet and pay my respects to their elders past and present. I'd also like to thank the editors of the UNSW Law Review, especially Amelia, for the invitation to come and join you tonight. As a former editor of Sydney Law Review, I could have been considered the enemy. So I'm very delighted that that wasn't the case. And it's a particular pleasure to be here tonight because I think we have a very important topic to discuss, and I think we have a wonderful article that is the stimulus for the discussion. As Harry and I discussed a moment ago, we already had an exchange a few years ago when Harry and Andrew submitted an article to Sydney Law Review, and that article attracted a great deal of attention, and Sydney Law Review ended up on the front page of the Brisbane Courier Mail because of the criticisms that the authors offered of the previous government in Queensland. As Harry said, it could be regarded as either a high point or a low point of an academic life, but I think he's off to a very good start if that's the kind of attention he can gain. That's the context for my presence here tonight. I'm a big fan of historical reflection on contemporary social problems, and I think it's particularly valuable that we have a piece tonight that sets a wide historical perspective on this very tricky issue of dangerousness. Harry and Andrew's article ranges widely, and once again I was impressed by their relatively sophisticated literary references that they combine with detailed legal study, their wide-ranging multi-jurisdictional coverage of law, and their freedom and reflection to think about contemporary issues in an historical way. As Harry and Andrew's article reminds us, the content of dangerousness has varied very significantly over time. We actually don't have to go back very far, only to the early decades of this century, to find that dangerousness was associated not with sexual offenders, which is the subject of the article of Harry and Andrews, but with property offences, and in particular with low-level property offences. These offences and thieves and low-level offending of that kind was considered to be likely to prompt to be a factor that went into recidivism, and also to be something that attracted genuine social fear and concern. And in my own work on mental incapacity, going back further, we can see over the 17th, 18th and 19th centuries the role of mental incapacity and dangerousness, the connection between the two. The idea that a mad felon, quote unquote, was someone who we needed to be afraid of, not just for what they had done, but for what they might do in the future. Harry and Andrew are right now to draw a connection between dangerousness and sexual offending, and I think they're also right to say this is something of a high point in social and political public concern. They draw attention to the legal concerns that we as lawyers all share with efficacy, with proportionality, with limits on state power, such as are required in particular contexts. And they draw attention to the idea that dangerousness is not a free-for-all. It's something that requires a scoped and careful approach to the offenders that are being labelled in that particular way, and of course, an appropriate recognition of the victims of crimes that they have committed. But dangerousness is not just a legal matter, and it's not just concerns with efficacy and proportionality that we should turn our attention to. And what I want to mention and discuss tonight briefly is the way in which dangerousness borrows clothing, if you like, and it has not only a legal identity, but also a medical or more broadly socio-legal identity. And it's here that I think we can add to our level of reflection about the concept of dangerousness and the role that it might be playing in othering particular individuals in the criminal justice system. So here I want to mention two different types of knowledge that we bring to the notion of dangerousness, because this is the way in which we can see dangerousness having this extra legal life. The first type of knowledge is expert medical knowledge. And here I'm thinking particularly now of psychiatric and psychological knowledge that, from the end of the 18th century and right up to the current era, plays a very big role in the kind of legal determinations of dangerousness, and then the responses we make, whether they be in the form of preventive detention, habitual offenders legislation, or otherwise. As we sit in the present era, it's hard to imagine a system where we didn't have reliance on expert medical knowledge. And in fact, we probably wouldn't want to be without it now. But it's worth saying that there was a time when dangerousness and its associations were a matter of lay knowledge. And in relation to mental incapacity, I would suggest that this hasn't entirely gone away. So, in the early modern period, and right up, in fact, until the 18th century, dangerousness in the form of, say, for example, madness was protean, but it was also familiar. It was the sort of thing that lay people, family members, neighbours, close associates could speak to when an individual came to be charged with an offence and sought to raise something like the insanity defence, the mental incapacity defence as we now know it. What the role of the medical evidence was as it came into the courtrooms from the very end of the 1800s was, I think, a very kind of clearly helpful role. It was an attempt to provide extra information about a defendant, perhaps to provide reference to other individuals who might be having a particular condition but not be charged with an offence. But at the same time as medical evidence came to be introduced into the courtroom, and we know it played an important role in the most infamous or famous mental incapacity decision, Daniel McNaughton, we actually don't see the erasure of lay knowledge. Rather, what happens is that lay knowledge still has a role on what is now a mixed knowledge field. Lay knowledge plays a role in the jury determination of the value of the acceptability of a mental incapacity defence, for example. And in addition, because we as lawyers are not medically trained, we could say we are ourselves lay with respect to expert medical evaluations, and we bring our own knowledge to cases, whether it be in defence choices to raise particular defences, prosecutorial choices to seek expert evidence, and of course judicial determinations about what it is that constitutes an appropriate outcome in a particular case involving mental incapacity. Now, what medical knowledge did to the concept of dangerousness was pretty profound. It didn't just suggest that dangerousness was something that could be known to specialists, and therefore that we would need to invite specialists into the courtroom in greater ways, or into pre-trial process or post-sentence process in the form of expert evaluations. It also gave us an idea that dangerousness articulates beyond act, beyond the familiar concerns of criminal lawyers with actus reus and mens rea. Rather, dangerousness became a type, something that goes beyond conduct and mental state in a snapshot moment and into character or into disposition, that it articulates over time and space in a way that is very different to the standard concerns of criminal lawyers, with a blink of an eye moment, the moment of coincidence of the mental state and the conduct element of an offence. And I want to suggest that this is really important for our understanding of dangerousness today, because when expert medical knowledge gave us this wider articulation of dangerousness, we came to see it as something that would subsist in a person despite his or her sentence being completed, despite indicators otherwise that might suggest recovery or rehabilitation. And this idea, I think, has stayed with us, such that we've lost some faith in the kind of options that we might otherwise take for offenders who commit particularly serious crimes. The label dangerousness does something particular. The second type of knowledge I think is important to consider in this respect is social scientific knowledge, the knowledge of society. And I think it's not coincidental that when this kind of knowledge was developing also around the same time, that we came to be able to think of our communities and our societies as healthy, just like a body might be. So we came to be able to measure by statistics and other kinds of knowledges the sort of society that we might want, how we were tracking, if you like. And this was, of course, well before our watches that encourage us to do various activities, etc. What it is that we were looking at there is something that we hadn't been able to cover before in the same way. And what that kind of knowledge, that social scientific knowledge did, is it extended the lens, if you like, that we could take on a particular individual's crime. We could then look back into his or her childhood. We could look more broadly outwards into his or her risk factors. We could look at statistics of success with rehabilitation programs and others, and we could go further, if you like, in our claims about what could be predicted on the part of for that person's future. Now, that kind of knowledge we now know as a risk-based or actuarial kind of knowledge. And we also know, as the authors point out in the article, the limits of that kind of knowledge. But one of the things I think we really also need to think about is the way in which we might be blurring some of the lines now, so that some of these types of knowledges are kind of being added together, 2 and 2, and perhaps coming up with 5, to keep up the mathematical metaphors for the night. Because what we may be doing is extending the extent to which we can be confident about future predictions. The role of risk, of course, means that we're no longer thinking about dangerousness as threat or danger, but rather about predictability, about likelihoods, about chance. And do we ever really say that the risk of something is 0? When we recognise the way in which these knowledges are kind of blurring, expert medical knowledge and social scientific knowledge coming together in particular ways, we can better explain things like the sexual predator laws in the USA that the authors also refer to in their article, where really what functions there is a sort of pseudo-medical diagnosis. There's the dangerous sexual offending is what gives rise to the pseudo-medical label that is supposed to then attract, licenses the state then to attract, to give particular kinds of sentences. So it's not just, as the authors say, that that definition is circular, although of course that is part of the problem, but it's also that that provides a legitimacy for a system that is is not providing treatment, in fact, but rather providing harsher sentences. So, where does that leave us? If we take into account these types of knowledge in our perspective on dangerousness, where are we at the end? Well, what I want to suggest is that we're at a very big question time. And the question I think to ask is what kind of society we want to live in. And the reason this is the question is because, of course, dangerousness is not something that's contained within the criminal law, even when you take into account medical knowledges of dangerousness around it. Rather, dangerousness is the same thing that we're talking about when we talk about threats to security, threats to the state in the form of terrorism, and other concerns that we might have. And so really, things like dangerousness in criminal law are actually just the vanguard of other issues about the kind of organisation of a social system that we might want to reflect on tonight. What kind of social system we would like to live in. And here I want to suggest three things. So this is the world according to me. In other words, what kind of social system I'd like to live in. The first thing is I'd like to see the kind of investment in mental health services and treatment and rehabilitation which would mean that we're not seeing the criminal justice system become a new asylum. I'd like to see the kind of system that doesn't let people fall through safety nets right until the point when we're talking about very serious criminal punishments. I'd like to see the kind of system that recognises the consequences of victimisation, particularly victimisation for children, and to recognise that when it comes to it, that may be something that is effectively having a criminogenic effect. And I think the Royal Commission, to mention it again, Michael, is actually something that is finally painting that picture for us so clearly that we cannot ignore it. And lastly, I'd like to mention that I think it's very important when thinking about dangerousness and sexual offending to actually remember that the vast majority of sex offending is not treated as exceptional. It's not about dangerousness. It's about everyday activities in the home, on the streets, in clubs, outside clubs, around us in the workplace and on campus. And this kind of sexual offending is the ordinary sexual offending of which women are the majority of the victims. And I think it's very important tonight when we're talking about dangerousness and sexual offending to remember that it's that kind of offending that constitutes the vast majority of victimisation. And I think tonight, when we have an opportunity to reflect on dangerousness, we shouldn't forget that we're not labelling certain other kinds of sexual offending as dangerous. Thank you.
It's a privilege for me to be asked once again to be present at the launch of the University of New South Wales Law Journal, Volume 41, Number 2, 2018. It's also a privilege to be here at Herbert Smith Freehills and to be with all of you, colleagues in the law. I don't want to start in what has become the conventional approach by acknowledging the traditional owners and custodians of the land. We all know why we say that. We all know in a legal audience why we have a special reason to say it. We were those who imposed through the law great injustices upon the Indigenous people that requires our country to try to come to grips with the obligation that goes with that. That obligation has an economic component and a political and a constitutional component. The problem with the legal mind is that it's often infected with a virus that leads to excessive formalism and an inability to look past the immediate issue with which we're addressing ourselves into the dark corners of the law. When I heard about the suggestion of the Uluru Statement that the Aboriginal people meeting in Uluru said, what we want is a voice into federal parliament, I had a very typical lawyer's formalistic answer. You can't have that. The federal parliament is there to represent everybody. They're part of everybody, and they'll get their voice with everybody else. Well, they don't want that. They want to have a special voice, an opportunity to speak directly to the lawmakers, not on everything. They don't want reserved seats. They just want to have an opportunity for a voice. And so I began to think about this and began to see that there was more in it than my formalistic answer led me originally to believe. And I think that's also true about the legislation on very dangerous prisoners. It's very easy to say the Act or these acts have been held to be valid. The High Court of Australia has held that they conform to the Constitution. The High Court has said that they don't offend the cable principle. That led me in Farden, or was it Baker, to say cable was the guard dog that barked but once. There have been a couple of little barks, not many. The problem with our law is that unless you get a bit of experience with addressing deep fundamentals, as you do if you have a Bill of Rights in your constitution or even a statute, you're just not going to think in a way that is sensitive to the fact that there are deep fundamentals, such as the gross overrepresentation in our prisons of the Indigenous people. That comes of just applying the law for what are usually minor cases of burglary and the like, and the result is that the Indigenous people are grossly overrepresented. They are the most overrepresented, they are the most imprisoned people in the whole world, even more than the percentage of China and the United States of America for the total population are our Aboriginals in our country. So we need an escape from excessive formalism. I want to pick up something that Professor Loughnan said about character, and it reminded me of something I wrote in the case of Farden. I used the German word Volksschädlinge. Volksschädlinge. My German teacher at Fort Street High School would be proud of my accent. I had a Sprachgefühl, and he taught it to me. Volksschädlinge was the endeavour of the theorists of criminal law in Nazi Germany to move away from this obsessive concern about the crime and the act, and to look instead at the character of the people. Volksschädlinge, you see, were people who were deemed, with the evidence of their actions, to be enemies of the people. And so I tried to warn my colleagues. It didn't have any consequence, and the case is a case where I am in sole dissent, as I was in Baker. People say the great dissenter. I don't like that expression much. It's sometimes used as a means to try to disempower those who speak and see a different thing and speak that to our people. But this is what I said in that case, which was about dangerous, excessively dangerous, very dangerous prisoners. One pattern of intrusion into judicial functions may be observed in what occurred in Germany in the early 1930s. It was provided for in the acts of an elected government. Laws with retroactive effect were duly proclaimed. Such laws adopted a so-called phenomenological approach. Punishment was addressed to the estimated character of the criminal instead of the proved facts of the crime. Rather than sanctioning specified criminal conduct, the phenomenological school of criminal liability procured the enactment of laws describing punishment for identified criminal archetypes. These were the Volksschädlinge, who had harmed the nation. The attention of the courts was diverted from the corpus delicti of the crime to a preoccupation with the pictorial impression of the accused. Provision was made for punishment or additional punishment, not for specific acts of proved conduct, but for, quote, an inclination towards criminality so deep-rooted that it precluded the offenders becoming a useful member of the community. So there's a precedent, you know, to a lot of this, and as was mentioned in the last words of Professor Loughnan, that precedent we're seeing in the punishment of drug offenders and in bikies and in terrorism legislation, and security legislation, and the dreadful way our country has dealt with refugee applicants in Nauru and in Manus Island. So, Volksschädlinge, just keep that in your mind and don't forget that I told you about it. And if you're interested, it's in Farden, and Farden is at 223 Commonwealth Law Reports. It was back in the year 2004, so it's quite a way back now in the past, and it's accompanied back to back with Baker. Now, Baker was a case, I don't think Mr Hadley was around back in 2004, Justice McCallum. He might have been, but he wasn't to blame for Mr Baker's faults. But one of that group of special media personalities who try to make our society very, very angry had called a group of prisoners, including Mr Farden, an animal. But Justice Greg James, who'd heard the case at first instance and who was trying to grapple with this legislation that put him into the character of Volksschädlinge, made a number of factual findings about Mr Baker, and the factual findings just didn't appear to support the notion that his character was such that he should have an indefinite punishment. He said, the statistical risk of recidivism is very low. The particular prospect of the appellants achieving rehabilitation is very high. His Honour said the evidence as to rehabilitation prospects was very powerful. Indeed, he said, that was not to any real extent challenged in the case before him. He quoted evidence describing the appellant's conduct in prison as absolutely exemplary. No suggestion of any conduct as would pose a risk to the community. He referred to corroborated evidence that the appellant had tried his best to behave as a peacemaker in the prison system, even when he himself was assaulted. He noted the appellant's own acknowledgement that he would take time to adjust being in the community after nearly 3 decades in incarceration. He quoted expert medical evidence deposing the appellant had accepted his sentence uncomplainingly and had shown for many years a consistent attitude of remorse and insight. The evidence in the opinion of the primary judge supported a view that the appellant could go into the community without reoffending violently. A forensic psychologist was quoted, with apparent approval by the judge, to the effect that the appellant's behaviour within the prison system was exemplary, his work excellent, and he had achieved a great deal by way of rehabilitation. So that was the man, Mr. Baker, for whom there was no remedy under our law. There was no remedy, and he was subject to a valid law which the court would not apply the cable principle to. I also quoted a very distinguished academic. She's now the Governor of Tasmania, Kate Warner, a really great criminal lawyer and a very fine expert in sentencing law. She remarked, "An obstacle to preventive detention is the difficulty of prediction. Psychiatrists notoriously overpredict. Predictions of dangers have been shown to have only a 1/3 to 50% success rate, while actuarial predictions have been shown to be better than clinical predictions. An interesting point, as psychiatric or clinical predictions are central to continuing detention orders, neither are accurate." So that's the central problem with legislation of this kind. But if the Parliament enacts legislation, and if the High Court holds that it's valid legislation, judges like Justice McCallum just have to do their best. Judges like Justice Greg James just have to do their best with this legislation which is so weighted against the Volksschädlinge. This is the difficulty we face in a meeting such as this, where we're thinking about this fundamental problem. Now, there's a very good essay in this collection of this work, which I thought I was coming to address tonight, which was my own brilliant essay on Where Does Truth Lie? And part of that is a story about the inquiry into North Korea and the inquiry in North Korea and about the human rights violations. They have Volksschädlinge in North Korea, plenty of them. They're put into detention camps, and their way of dealing with the problem is they look on Volksschädlinge as people who infect the generation before and the generation after. That's what happens in North Korea. If you are regarded as politically dangerous, they not only put you with your acts of suggested antisocial conduct, but they put your mum and dad and maybe your grandpa, and then they put your children in too, because you are infecting society. That's the problem with Volksschädlinge. And now we have President Trump, on again, off again, but he'll probably have a meeting. And you know, it's really led to my real concern, which I can't resolve. Given the tremendous, tremendous peril of nuclear weapons, do we say that even though there are crimes against humanity, and even though the international community said it would always respond to crimes against humanity in the light of the Holocaust, do we say, well, we're sorry, nuclear weapons are just too big a problem. The dangers to society, to the world, are just too great, and we've just got to turn away from that and try to reach nuclear peace and non-proliferation and destruction and stockpiles. So these are the questions we have in society where there are issues of dangerous. It's a kind of risk management that society is undertaking, and the way parliaments and others respond to that is to pass legislation of the kind that was dealt with in Farden and Baker, and that is still being dealt with in the courts, the judges doing their very best. But thank goodness there are judges who are not blinded by formalism and who look behind the words and look at our constitutional arrangement and look at what kind of a society we would like Australia to be. And to the extent that that is permitted by the law, that's a very good thing, and more Australian lawyers should do it. So to the extent that this new volume of the University of New South Wales Law Journal contributes to that objective, And to the extent that the article by Harry Hobbs and Andrew Totter contributes to it, I think it's a very good thing. Long may academic scholars continue to question a purely formalist approach to the issues that are presented to us by our Constitution, by Chapter 3, and by the obligation to protect the fundamentals that are so easily cast aside.